Hey, good morning, everybody. I'm not sure what we're listening to, but it made me want to go back to sleep. Welcome back to Law and Legitimacy. It's Wacky Wednesday, I think. And we're at that time of year where the Supreme Court is very active. In fact, there's but one day left for them to announce decisions, and that's tomorrow, at least according to the calendar they have published online. Tomorrow is a day they may announce decisions, and the decision we're all waiting for, or actually the decisions plural we're all waiting for, are the affirmative action decisions. As you know, in a case pending before the court, in two cases pending before the court, one from Harvard, one from the University of North Carolina, the question presented is whether race-based classifications are permitted as a matter of law in both private universities and public universities. In the public universities, does it violate the 14th Amendment Equal Protection Clause? And I presume similarly in the private university Title VII context, are we equal before the law, or do some people get points because of who they are in the name of DEI, diversity and equity and inclusion? You know which way we're hoping the court will vote. Let's see what happens. We'll discuss it tomorrow. But we had some interesting decisions last night or yesterday. One of them, Counterman versus, I think it was Colorado. Yeah, had a chance to read through it this morning. And I thought we'd unpack it a little bit today because, you know, we talk a lot about First Amendment rights, and there being exceptions to the First Amendment. You don't have a right to say anything you want, wherever you want. Although the First Amendment says Congress shall make no law respecting freedom of speech. But, you know, we recognize restrictions in the area of defamation, criminal conspiracy, inciting violence, and then in the case of Counterman versus Colorado, true threats. The true threat jurisprudence in the country has been a little confusing in recent years. There's been a split in the circuits because it's unclear what a state can be permitted to prove to obtain a conviction for truly threatening someone. So in the Counterman case, we'll give a brief recitation of the facts. It appears to be an internet stalking case. Counterman developed a thing for CW. I don't know who CW is. A local singer and musician, she is described as. So
I think CW is just stand-in for Colorado woman. They're protecting her identity for purposes of this case.
So Counterman developed a thing for that Rocky Mountain High chick, CW Colorado woman. And he started following her and sending her notes. You look good this morning. I'm out now. Can I get you something for breakfast? And the notes began to take a menacing turn and suggested that he was, in fact, stalking her. I saw you out with someone last night. Bad look. You know, you're not contributing to the world's welfare. And then there were expressions in there, and I don't remember the exact one, that bordered on the urge of violent or portending violence. CW took these remarks to heart, and she began to not go out as much. She began to cancel gigs. She became wary of her surroundings in ways that she wasn't before, and she was wary of Counterman. Counterman was stalking her. He wanted her attention, probably imagined her as a romantic object, and became frustrated and angry and menacing when she wouldn't return his anonymous inquiries, his anonymous expressions of affection. She complained. He was tried in Colorado under a statute that makes it against the law to utter things that put another person in fear for their safety, repeatedly utter things that puts another person in fear for his safety. And so you're thinking, as I am, well, what's wrong with that? I may say today, anybody who votes for Joe Blow, he ought to jump off a bridge. I can't believe people would do that. Does Joe Blow think that I have truly threatened him in that case? Well, probably not. And so there were some circuit courts took the position, and so that you had to have a lot of culpability. Others took the position you had to have less. What am I talking about? I'm talking about mens rea. Now, remember, a state of mind, what's in your head. To commit a crime in the United States, typically two things have to occur. You have to engage in some prohibited conduct. You can think whatever you like. We don't have thought crimes, at least not yet.
Well,
Law and legitimacy, convicted. Yes, we are bad people. We have bad thoughts. That's between you and God, presumably. I mean, when Bill Clinton lusted after a woman in his heart, nobody got to cry rape, at least in terra firma. Maybe in heaven, but who knows? We're not in heaven; we live on earth. So you've got in terms of men, you have to have an actus reus, a prohibited act, accompanied by a culpable mental state. And so, what are mental states? There's purpose. I have the purpose of accomplishing such an act, or I know my act is likely to yield bad contact, or I could recklessly engage in conduct. I could be aware of a substantial risk of harm to another person and nonetheless act. That's one way of looking at the culpability scale. Another way of looking at it is to say that there are specific intent crimes, that is where you have an unlawful purpose. There's general intent where you engage in conduct without necessarily having the purpose of harming another, but you engage in prohibited conduct. And then there's recklessness again, and then there's ordinary negligence. How do you distinguish between these things? The law talks in terms of standards. And so there's an objective standard and a subjective standard. And you're sitting there thinking, what the hell is this guy talking about? It's the First Amendment. Unfortunately, folks, I'm talking about the law, and I'm making it as simple as I can. And if you think I'm making this stuff up, read the Counterman versus Colorado decision. It's a decision by Justice Kagan, and it's one of the best First Amendment decisions from the Supreme Court I ever read in terms of explaining the law, the history of it, and the concepts that are at stake.
I have to agree. And I think that, if any of our viewers, listeners know any current law students, I would highly recommend that they just suggest this case, not for any ultimate outcome, but for what Norm just talked about. It's rare that you're going to see an opinion that is as clearly written as this and will take the time and exercise the patience to develop the law, the history, and then to go into the nuances in a way that can be easily digested. I put this, Norm, I want to read a little bit from what I've got on the screen here. It's from page 4 of the opinion, and this is where...
Before we do that, though, I want to explain what the court actually decided, because all this was by way of a setup. I'm sorry, Mike, I didn't mean to cut you off, but I see the chill language in there, and I do want to get to that, but I want people to understand what the decision says. So the decision... There was a split in the circuits. In other words, some federal appellate courts said that you had to specifically intend a true threat. In other words, you had to have the purpose to threat. Others said no. The consequence of your action to a reasonable person was enough. So if your conduct it was likely that a reasonable person would be offended by it, and you nonetheless engaged in that speech, that's enough. The court said, no, we don't agree with the easy standard, but we don't agree with the hard standard either. The court basically said that recklessness is enough. And this is the kicker, and this is what makes the decision hard to apply. It's not recklessness from the standpoint of an objective person. When the court talks in terms of an objectively reasonable person, basically they're talking about a legal fiction. I've never met an objectively reasonable person. An objectively reasonable person is a consensus of a group that decides to evaluate conduct and come to an agreement about what they think a person should or shouldn't do by that standard. And the law is filled with these standards, and it wouldn't work otherwise. That's the importance of jurors, and frankly, the importance of what we talk about all the time here, legitimacy, a common conception of right, a commitment to core values. So what the court held here is that an objective assessment of reasonableness is not enough to convict. You have to show a subjective awareness on the part of the defendant that he engaged in reckless conduct. So recklessness is enough, but it has to be evaluated by a subjective standard. What the hell does that mean? Now, in a pure recklessness regime, it would be enough, an objective recklessness regime, it would be enough to put up publications from a person, statements from a person, and say, ladies and gentlemen of the jury, you saw, we've shown that Mike said X, Y, and Z. Is there anyone here who really believes that that wasn't done in reckless disregard of the danger that it would make Norm feel threatened? And if the jury all agreed, that would be enough. The Supreme Court, and that's what Colorado's statute said. The Supreme Court said, no, that's not enough. You have to show some subjective awareness on the part of the defendant. I don't know how you do that, because in a criminal case, you cannot require a defendant to testify. A defendant has a right to remain silent. So I presume that you would have to go through the communications and look for one that says, I realize this could cause her distress, but I don't care. Or an admission from the person saying, I hope she's upset about this, or some other conduct, because on a purely objective standard, it simply won't be enough, I think, under Counterman, to present the email thread and say, this is proof. I think you've got to prove more. You've got to prove something. You've got to have either direct or circumstantial evidence of the person's state of mind. And Mike, this is where the kicker is, and then I'll stop because I realize I'm rattling on here. What are you going to do in a case where all you have is outrageous internet communication and no more? I think then this distinction between subjective and objective will reach the vanishing point, and it'll be what lawyers call a distinction without difference. Because what prosecutors will say is, we've got to show the defendant subjectively knew that his words could cause harm. You've read his text messages. What else could he have been thinking? And at that moment, the subjective standard becomes the objective standard, because the jury is substituting its judgment for the judgment of the defendant. And so I think this decision is really no decision at all. It sounds like it's moved the law in the direction of protecting speech, and it might inhibit prosecutors from bringing some cases, but in hard cases, it's the same case.
And I want to be clear, because I think that the toughest thing and I would consider every law student still a civilian when I use the word civilian, but so a non-practicing attorney, a non-bar licensed attorney, some of the most difficult lessons one learns in law school is to distinguish between to recognize when one is feeling as though a certain outcome should come from a set of facts and what the court is actually narrowly focused on. In this case, I do think that the subjective standard that the court outlines would be met. The issue is that Colorado prosecutors did not make any effort to show that the defendant knew his statements to be threatening from that perspective.
But here's the problem I have, Mike. What would prevent them from just adding a sentence to their closing argument? You've seen those words. We have to show that he knew that these would be threatening. Well, what else? I mean, you can infer, ladies and gentlemen, that he knew from the statements themselves. And at that point,
I understand what you're saying, but I don't know that there's really, I don't want to say it's much ado about nothing, but it is important, because I think that every individual has the capability to assess whether communications directed to them are indeed threatening in their subjective interpretation. And in this circumstance, we have a fact pattern that says that this guy engaged in a pattern of conduct online via Facebook, sending messages. Not only was he blocked on several occasions, but each occasion he was creating a new account and continuing on. That's why I say it's an easy leap to make to say that subjective standard would have been met should the prosecutors just have been wise enough to say, and he knew, because he kept getting blocked. She kept making the minimum necessary effort to push his communications out of her online sphere. So here's the defense lawyer in me. All that, so he said, come hither. She said, no. He said, come hither again. Is that a threat? Or is it just annoying? Okay. One creates another Facebook account to circumvent a block, right? There's pattern. All I'm saying is,
but is that a threat?
Is that a threat? Again, it's sort of a subjective interpretation. All it would take, really, from my reading of this, is for the plaintiff or the petitioner, rather, or the CW, we'll call her, to say, I find your statements threatening, continue contact. Even something even more simple than that would have done the trick here. Right.
Well, I think that may be right. So some sort of notice requirement to the
1,000%. That does it. In a digital world, everything is archived. So
that's a great point.
It's not as if this is a tall burden that you're pushing on people. You're actually giving people agency to say, "Hey, shut up! You're making me uncomfortable."
You were about ready to comment on some language in Section 2 when I cut you off, and I see the word chill in there, and I think that's where this decision is really eloquent and sheds a brilliant light on what's at stake in First Amendment litigation. What were you going to say here, Mike?
Well, I was actually going to read from the footnote because I found that really, really helpful in setting up and framing the question that the court would be answering in this opinion. And so there's the sentence that said, the first dispute here is about whether the First Amendment nonetheless demands that the state in a true threats case prove that defendant was aware in some way of the threatening nature of his communication. So I was just talking a little bit about this, but the footnote says this: a preliminary clarification may be useful concerning the difference between awareness of a communication's contents and awareness of its threatening nature. Everyone agrees again that the state must prove the former, and Colorado law appears to hold as much. So, for example, if a defendant delivers a sealed envelope without knowing a threatening letter is inside, he cannot be liable for the communication. So too, though this is common example, fairly preposterous, if a foreigner ignorant of the English language who would not know the meaning of the words somehow manages to convey an English language threat, right? And so it goes on to just say the question in this case arises when the defendant, unlike in those hypothetical, understands the content of the words, but may not grasp that others would find them threatening. Must he do so under First Amendment for a true threats prosecution to succeed? That is the narrowest of possible questions that this court could answer. And sure, there are pages and pages and pages of this decision, but ultimately, what I take from this is that individuals should have agency. Now, I don't know how this scales, right? I don't know how this would scale to say, you know, someone posts something online on Twitter, right? And then a bunch of people see it and then they say, this is threatening, right? That's not how this would work. But at least in interpersonal communications, we have an example of how online speech can be curtailed for First Amendment purposes as between a dyad, as between two individuals in a private message.
So Pat Clifton, the other angry dog, says words have consequences. Pat, look at the language that's in the middle of the larger text on the screen. Counterman's view, we decide today, is more consistent with our precedent. To combat the kind of chill he references, our decisions have insisted on protecting even some historical unprotected speech through the adoption of a subjective mental state element. What that means is that because we have as a core value in our jurisprudence freedom of speech, we want to be wary of statutes that make people afraid to use it, that make people wary to speak. And we want to have standards that place people on notice that what they've done could expose them to the expense of litigation and the potential of incarceration. So the court's chill language says, look, by tilting this recklessness standard in a subjective standard, we're eliminating some of the chilling effect of the objective standard, as it could be used in this case, where people are held responsible for the consequences that others impute to their words. So that
a parting shot on this before we transition, Norm, and not to say that this is the last.
No, we should. Yeah.
But the mens rea, the mental state aspect of this, because every crime is actus reus, mens rea, actus reus, those two things together, blah, blah. But the mens rea is important because the court goes through quite a lot of effort to compare what recklessness is under a true threat exception to the First Amendment by comparing it to defamation as another one of the various exceptions to the First Amendment. So, for example, knowledge of falsity with reckless disregard of the truth. Right, that latter part is something that they draw comparisons to, and that's a lot of what the concurring opinions and the dissenting opinion talks about is whether it's appropriate to assess a mens rea for purposes of the subjective standard, that intent element that a defendant needs to be analyzed through, whether it's fair and accurate, and I guess holding with current precedent. To compare those levels of recklessness for something like a true threat.
Well, so Counterman's there. We've pushed the direction a little bit in favor of speech, but perhaps not as much as some of us would have preferred. And we've got now a new fundamental law of the land. Everybody read Counterman versus Colorado. If you're curious about the law, it's a great education for lay people. Judge Kagan, when the originalist jurisprudence, people who are originalists like Thomas, their decisions have a tendency to read like bad doctoral dissertations and your eyes glaze over. Kagan speaks right to our times in ways that I really appreciated. I want to acknowledge a couple comments in the chat. It's me again. Sai says, I'm late, but I would be interested in hearing Norm's opinion on Michigan's bill, which can fine up to 10K or get you 5 years in prison if your speech is hateful. We're looking at that. It's me again, Sai. I think the Senate has passed it in Michigan. I'm not sure the House has. Again, it all depends on what the definition of hate speech is. And so I think hate speech would have to be speech that was intended to convey a threat of some sort to a person on account of that person's characteristics, whether that be race, gender, or some other protected class. I generally don't favor hate speech restrictions at all, or hate speech or hate crime enhancements at all. Something's either against the law or it's not. I think in enabling people to bring claims against others on behalf of their innate characteristics, I think encourages divisiveness and encourages a sort of creation of needless silos in American life by leading some people to believe that on account of their immutable characteristics, they have more rights than others, or those rights mean more in some context. But we'll report more on that in time. We have another longer comment from a new listener who appeared yesterday, Dawn McNeil. Follow up.
Hey, Dawn.
When does an institution like the FBI become so corrupt and antagonistic to justice that it is irredeemable and must be dismantled? When does it lose its legitimacy? When is it too late? Dawn, if I knew the answer to that, I'd be living on a mountaintop somewhere selling shares in wisdom. I don't know. I think that the problem of legitimacy is a concept a lot like felt necessity. There are some things that or it's like Justice Potter's definition of obscenity. He can't define it, but he knows it when he sees it. The classic discussion, the best discussion of the concept of legitimacy that I've ever read, comes from an author named Max Weber, who in the early 20th century wrote or gave a lecture in Germany called Politics as a Vocation. And in it, he talked about sources of legitimacy and basically said there are three. There are things that we believe to be fair, just, and reasonable and right because they've always been right. That's tradition. There are times where we follow someone and believe them to be right because of their charismatic personality. Charisma being a Greek term, basically meaning gift of God. And then there are rational forms of legitimacy where we believe an institution is right or a behavior is right because it's been created by rules and we understand and respect the rules. I think judged by any of those three sources of legitimacy, the FBI and government in general is in trouble in the United States. And here's the classic example. What's the difference between, Weber said that the state is that entity, government is that entity that has a monopoly on the legitimate use of force. And so legitimately used force is authority. It's by the state. What's the difference between being stopped at a street corner by a guy in jeans and a t-shirt with a gun and a cop in uniform with a gun? For most of us, there's a big difference. Jeans, t-shirt guy, who are you? What's up? You put your hands up. You probably give him what he wants because you're scared to death. Cop comes up, you probably give him what he wants because you're scared to death. But in a healthy society, you look at the officer as bearing the indicia of the state and authority, and you're inclined to give him the benefit or her the benefit of the doubt because of legitimacy. When you look at your institutions, or when you look at a police officer and you can't distinguish him from a civilian, his show of force is no different than a gang member's show of force. You're living in a society that is crumbling. And so, Dawn, the very fact that you can ask this question of the FBI suggests that, in your view, the FBI is lacking and is coming to lack legitimacy because it's behaving in ways that you find to be unjust. And I would agree with you in some fundamental ways. And I don't know that there's a magic moment. I think society, it's not like there's a convention of citizens at some point illegitimate. I think legitimacy is lost by degrees. And you see people opting out of systems. You see people choosing not to have respect or regard for public institutions and resolving to private means of resolving things. So Dawn responds by saying, Good morning. Norm just seems too hopeful about the institutions. Exactly right on Weber. He also wrote about the iron cage of bureaucracy. I'm a sociologist. Dawn, so you know Weber. And so, you know, we live in a disenchanted world, according to Weber. All these rules don't have a source in anything transcendent. And the result of this disenchantment is despair. And so in his parallel essay, Science as a Vocation, he talked about, you know, the quest for truth. Being alone and being sufficient, the request, you know, the desire to understand that, and you know, and then he talked about politics being the slow drilling against hard boards. Where we come with from with our convictions, where we arrive at our convictions, Weber couldn't really answer. And I think the challenge in a pluralistic society, the challenge of our time, is that we lack a common narrative, a way of devising a common set of norms, a common set of goals, a sense of legitimacy. I actually don't think I'm too hopeful, Dawn. I think I'm actually deeply pessimistic about them. But as a lawyer, I still believe the institutions function. I don't know that I can declare yet at this point that the FBI has become so corrupt we ought to dismantle it and dismantle the federal government. I'm very much with John Locke in the appeal to heaven. I think that the people have a right to revolt. The people have a right to replace their government. Our founders knew that. But what did Emerson say? When you shoot at the king, you best win. And I'm not sure we're at a point of absolute dissolution yet.
Yep. So, you know, Dawn also said, what's the difference between an institution that uses illicit means to catch bad guys and one that uses illicit means to catch good guys and political opponents? And obviously legitimacy, that is the defining characteristic. You know, there is, I think, describing a sort of that give and take of the subjective norms of a society, and sort of we can make an homage to the presence or the importance of some sort of moral backbone, right? Something that exists outside of us, something transcendent to guide a society for consistency, and predictability, and also trust. But one thing that I'm coming to grips with, or that I'm wrestling with lately, has a lot to do with what we've learned about the infiltration of social media companies, namely Facebook, Twitter, and even YouTube and others that have monopolies over various forms of online communication and the presence thereof of intelligence assets from the federal government, whether it be the NSA, the FBI, the CIA, what have you. And I'm beginning to sort of ask the question of what difference does it make if society regards something as illegitimate, as an institution as illegitimate, if it lacks the means to point it out accurately and simply and then do something about it. Right.
Well, I mean, you know, so how we arrive at a common perception. I mean, so now that I know Dawn's a sociologist, I'm nerding out on sociology. There's something called the sociology of knowledge. I mean, how do we create a collective sense of what's real and what's good? When we recognized universities as authoritative sources of information, you could look at think tanks and say, well, they're to be trusted. But now we've got a fissure between elite and populist institutions, where we have some say that, you know, the mainstream media, elite institutions, they've lost track of the interest, of the sense of reality, of the felt necessity of ordinary working people or people in despair. And they're describing the world they live in and the world they want to live in, rather than the world that others actually live in. And the crisis of American politics is that there is no one there to bridge that gap. Dawn, what we're trying to do on law and legitimacy, and you know, you say you see my hopefulness as a sign of pragmatic necessity. I'm not so sure about that. Here's what I think. I know that to get here today, I got out of bed. I used products that were created in a marketplace, and I trust they wouldn't kill me. I stuck the toothpaste in my mouth. I used the dental floss, the mouthwash. I used deodorant. Yes, I'd use deodorant. And then I got in my car, which I purchased gas last night from somebody I never knew, put oil in the tank because the gauge came on. I trusted the gauge was right. I don't understand how it works. I used the oil I bought from a stranger. I drove. I obeyed traffic lights. I saw people on the street. I chose to honor the traffic lights so they could pass. Nobody shot at me. You know, I'm using technology right now to communicate with you. And so all of these things are are expectations that I have every morning. And I think they're expectations we all share. And it's my opinion that we still all share and take for granted and rely upon many expectations. And thus, we haven't lost all sense of a common sense of legitimacy. We still most of us in our behavior recognize the same reality, and out of a sense of utility, we recognize common norms. So I don't know.
It's like there's also, I don't want to get too heady here, and I'm not saying I'm too smart, but what I'm saying is that there's pragmatic necessity, and then I also think about the role of historical memory in preserving traditions in society. And it seems as though we are in a moment right now where our historical memory has somehow been abridged. And I say that because I've been listening, and I shared this with you, Norm, the 6.5 hour podcast from Daryl Hoover, Martyr Made podcast, his most recent one, part 2 of, I believe it's sort of a race relations deep dive. And he traces the presence of African Americans and Blacks in America from the late 19th century into the 20th century. And I'm blown away at my own historical ignorance of the period between the 50s to the late 70s in particular, right? It feels as though what I'm observing as a 33-year-old man living in 2023 America, and a lot of what we're seeing online, the riots of 2020, the sainthood of George Floyd, issues with law enforcement, it can seem like such a long time, 50 to 70 years ago, but really it's a blink, and we're not that much different as a community, as a society. And in particular, I think I'm referring to what happened to Newark, New Jersey, right, with the riots, how that city never recovered.
Well, let me look. Yeah, I'm a little bit older than you. I mean, I'm old enough to be your daddy. And so I was a kid in when Newark went up. I was a kid in Detroit in 1967. And so when I hear people whine and rage about the racial tension in our time and our violence, you don't know nothing about violence. Even as shocking as the summer of 2020 was, it wasn't anywhere near as violent or as destructive as the summer of 1968 was. And so, the commodification of race and the means of using it as a way of manipulating the market. I mean, whether we need to do so on behalf of social justice, I have my doubts about what the use of race as a means of achieving social justice. Whether others find it to be a useful tool in a competitive marketplace to get an advantage in one form or another, I don't have any doubts about that. And I think changing demographics explains a lot about the use of race. I see severe conservatives comment on the Beverly Gage bio on Hoover. I don't know what I said yesterday, but I did tell everybody, you need to read that thing or listen to it. Beverly Gage is a former journalist and now faculty member at Yale, and she's wrote a book called G-Man. It's about Herbert Hoover or J. Edgar Hoover, excuse me, J. Edgar Hoover and his creation of the FBI and the challenges that the FBI surmounted from the 1920s into the 1970s. Of course,
whose name all is in the foreword of this book that was recommended by another viewer that I've just cracked open early this morning. It's called Weird Scenes Inside the Canyon, Laurel Canyon Covert Ops and the Dark Heart of the Hippie Dream. Now, we talked about this stuff before, but this is sort of what's inspiring a lot of what I'm thinking through historically right now, and how social media appears to be the new engineered battleground for political ideas and warfare, right? Ultimately, social engineering in the United States. I think about the migration of Southern Blacks into major cities, right, at a certain point in America's history, and the consequence that was called white flight, et cetera. And I'm trying to draw historical distinctions between that and then what's going on with us importing hundreds of thousands of migrants from outside our borders and shoving them into major metropolitan areas, and what we're likely to see as a result of that. Can we look at history to draw meaningful comparisons and insights from how politics developed in the United States based on that? So I don't know. We had a lot more planned today. Norm, I at least want to.
Yeah, where'd the time go today? What happened?
Before we get out of here, give you a chance to tell your story. I think it's awesome, and we can pick up on it in terms of the First Amendment.
Oh yeah. So listen to this, folks. So I decide I need a new person here. I need maybe two. So we've got feelers out, and so into my office yesterday was coming someone to work as a paralegal. and potentially part-time office manager, split the office manager's function. I'm reconceiving the roles in the firm. Word gets out about this person among the staff, and somebody decides, they look her up on Twitter, and they see that she had appeared at a protest against our governor, Ned Lamont, because Ned Lamont was using executive emergency powers to impose a mask mandate on school children. So this person spoke out against it. So one or more people in my office decide, well, we don't want to work with her if that's her view. And so I get wind of it. I write a note on the office note thing and say, look, I'm not looking for anybody's point of view on this. She's coming in. I trust you all to be professional. Well, they weren't. Next thing you know, somebody's printed up some posters and they've posted them around the building, including on the front door, suggesting that she's not welcome here. I don't know exactly what it says. I still haven't seen it. So suddenly later in the day, I'm sitting in the interview with her. And during the interview, somebody mentions to me that this poster was on the front door. And I said, well, I gather you've seen the poster. Yeah. How does that make you feel? And she kind of giggled and we laughed about it. And I said, a law firm is a collection of strong personalities, people with differing points of view. Apparently we have some here, but here's the irony. Our firm sued the governor on those mask mandates. So I've got one or more people who are sitting in my office content to take a paycheck to process litigation against the governor, but they don't want somebody who apparently protested against the governor here. So now what do we do about that? I mean, it was awkward. It actually was kind of funny. In the end, I had her sign a couple copies of the poster, and I'm going to have them framed and give her one. Whether we come to terms and she comes to work here, I don't know. I don't know if she'd want to after that. And I think that was the point, that people were trying to make her feel unwelcome. It was counterintuitive, though, because if you're a contrarian, it's like, oh, thank you for the rent check for the space I've put in your head.
I love it. Norm's office has a deep state.
Yeah, everybody's got a deep state apparently. So the question is, what do I do about that? Should I fire? Should I conduct an inquiry and find out who did it? I don't care. I mean, we're all adults here. Deal with it. But under Connecticut law, where I'm a private employer, so people don't have First Amendment rights to speak in the employment context, because the First Amendment is a right that you have against government. But under Connecticut law and many state laws, the state legislature has given employees First Amendment rights. So under Connecticut General Statute 3151Q, you cannot fire a person because of their protected speech activities. Now, whether that activity went to create a hostile work environment, whether that person is openly, insubordinate or whatever, I don't care. I don't particularly care about my employees' points of view. I care about whether they can get the work done. But yes, I have a deep state.
It appears as though the candidate you're bringing in, that's all that she cares about as well, right? I'm just here to do it.
Yeah. And I think my firm I think I survived a cancel culture coup yesterday. But whether I can survive it another day, you'll have to tune in tomorrow at Law and Legitimacy to find out.
That's absolutely right. I guess we can get out of here on that note, but it's been fun today. I think the Counterman thing is a great introduction to SCOTUS opinion reading for those that are interested in finding that. Norm, if you find any paralegals to send my way, tell them that there's someone in North Carolina looking for one.
But do we have a content? Are there things that they can and can't believe before you'll permit them to work with you? I mean, God forbid that anybody around you might be challenged to think or take an introspective point of view.
Yeah, victimhood is disallowed.
All right. So tomorrow, plenty to talk about. We meant to get back to the AG thing in North Carolina. We'll talk about that. We'll talk about the Harper decision from the Supreme Court, another North Carolina case that was issued today. Stay tuned, folks. There will be more decisions coming out from the Supreme Court tomorrow. It's that time of year.
Yeah, brace yourself. The affirmative action cases, those opinions will be, I expect, probably today or tomorrow. But because of how tense things are, I wouldn't be surprised if they waited until right before the weekend as well. I think Norm just let himself out. So I'll go ahead and close it up for everyone. Thank you for being here. If you're an audio-only listener, thank you. Leave us 5 stars or leave us alone. You can find us on Apple Podcasts, Spotify, Google Play, Overcast, etc. Here comes Norm. I'm going to add him back in. Did you need to look? He did it again. Do you need to duck out for a second?
I got canceled. The deep state struck out and grabbed me by the legs.
I was halfway through my rant. Follow us on Twitter. This podcast, please share the stream, subscribe, enable notifications. I know Rumble is a little bit of a delay sometimes in the mornings, but we're live right at 8 a.m. Eastern time. Thank you to the new viewers. I believe Dawn had to get to pickleball, so she's not here. But Mari, thank you for being here. Severe Conservative, nice to see you. Always nice when you're throwing something for us to chew on in the chat. Over on Rumble, Bathtub Liquor in the Cloud, it's me again. Thank you, as always, for being here. I love that we've got a community of people that are talking to each other and sharing ideas. FreedomLover, you as well. Maybe Lawyer Will show up, one of these days. I know Pete Atkinson is, as busy as it gets, but
Pete's advising the Pope on righteousness. I mean, somebody's got to do it, right?
That guy. Anyway, Norm, we'll be back tomorrow morning to talk about Attorney General Josh Stein here in North Carolina, Planned Parenthood v. Stein, and what's going on with the executive branch of North Carolina's government, with a state attorney general who is also running for governor, and a governor who is a lame duck with at least 6 of his bills or his vetoes overridden just yesterday.
All right.
In the legislature. So anyway, ciao.
Ciao.